and welcome to PubK's 2023 Government Contracts Annual Review. We're thrilled to have almost 4,000 registrations for this entire program. Over the next 4 afternoons, we'll present 10 additional sessions. We hope you'll be able to join us for most, if not all, of these sessions, but a separate registration is required for each session that you want to attend. My name is Alan Schwatkin. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. The PubK Group consists of 4 newsletters: PubK Law, PubK Compliance, PubK Cyber, and our newest that was launched in mid-2022, PubK M&A. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you who are joining this annual review are not yet subscribers. I hope you'll consider becoming a subscriber. Information is at the website shown on this slide or is available from any of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and capabilities these firms have and reach out to them as your needs arise. Also new in 2022, PubK joined with Arnold & Porter to launch a periodic podcast called Bonafide Needs. It covers emerging issues and interesting interviews. We'll continue that in 2023 as well and encourage you to access those podcasts through our website. If you're interested in partnering with PubK on a podcast, we'd be pleased to discuss this opportunity with you. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including the military, and here in the Washington, D.C. metropolitan area, I hope you'll consider making an individual or an organizational contribution. Since the entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout the sessions. But we welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it will not be possible to answer all of the questions in real time. We are capturing your questions and will endeavor to answer as many as possible after the conclusion of the annual review. However, all presentation slides, along with the audio, are available now for download from the PubK site, at least the slides are, and probably within a week or so, the audio and all the presentation slides will be available at the conclusion of the full annual review for the entire program. We'll send an email when this information is available for download, how to access it, and for how long the material will be available. We're also applying for continuing legal education approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. But if you're interested in obtaining CL8, you have to let us know, and please look for our poll question during the presentation. The state boards require us to verify your participation during the event. Don't worry, we'll keep track of responses to verify that you viewed the panel. And if you don't wish to obtain CLE credit, just disregard the poll. Now I'm thrilled to continue this 8th annual PubK review and our Session 2 panel on investigations, disclosures, and suspension and debarments. Our distinguished panel members back for another year are Dave Robbins at Jenner and Block, Fred Levy at Covington and Burling, Todd Canny from Pillsbury. Todd, over to you.
Thank you, Alan, and excited to be with you again this year and to be joined by my former colleagues, Fred Levy, when we were together at McKenna, and David back during our Air Force days. So today we have a very exciting and I think a little unique in terms of presentation, but we're going to be walking the audience through a hypothetical, how we would approach it from the investigative stage, the analysis of whether to make a disclosure, and if so, which offices to disclose to and the timing of the disclosure, and then getting into the real meaty components of the disclosure, and then engagement post-disclosure with the S&D offices, suspension, debarment. So very exciting material today. We hope you'll enjoy it. Just to make sure everyone is on the same page, I first want to start off with a few moments of background on the U.S. government's remedies standards in these different proceedings and then parallel proceedings. So with that, first, everyone is familiar, I'm sure, with the idea that a contractor can be pursued for criminal prosecution, right? And in that context, we're dealing with federal prosecutors and investigators. You can be pursued for a multitude of violations of criminal law. Now, contractors are also facing, a unique civil fraud recovery tool, which is called the False Claims Act. Again, civil FCA prosecutors at DOJ, investigators and relators are involved here, whistleblowers. Here, the contractors are facing treble or triple damages plus penalties for each false claim. So not only does DOJ have the power to wield this criminal tool and this civil FCA tool, but then each agency has their own suspension debarment official, or you'll hear SDO. So in this context, and I think perhaps one of the more damaging weapons in the government's arsenal, with the flick of a pen, an SDO has the power to put a contractor or individuals within the organization on the suspension debarment list. These cases are often investigated and developed and then referred to the SDO's office by the agency IG or the agency investigators. But the cases can also come from the contractor disclosures, from whistleblowers and contracting personnel. And then a remedy that we're not going to dig too deep in today, but I wanted to cover it just to make sure everyone's aware, is the termination for default remedy, right? So these are the remedies the government has when they're used simultaneously. They can really prove to be a incredibly strong set of weapons in the government's arsenal. With that, we'll move to the next slide. Now, I just want to briefly spotlight the different evidentiary standards for each of these actions. And it reminds me of my days working with David in the Air Force, where a fellow prosecutor said, this suspension tool is quite incredible. And the reason they made that remark is because of the very low evidentiary standard and the power and devastating impact that it has. So as you'll see on your screen, with adequate evidence, which can be likened to probable cause, the evidence needed for a search warrant, a debarring official can put a contractor immediately ineligible. And that process can play out 12 months, even 18 months with DOJ requested approval. So that's to initiate a suspension. A proposed debarment requires preponderance of the evidence, very consistent with the civil evidentiary standard to bring to obtain a civil judgment. And then, of course, criminal liability requires beyond a reasonable doubt. Let's move on to the next slide. Now, here, what we just want to highlight is that in this very sophisticated enforcement environment that contractors are facing, we have DOJ, we have these agency debarring officials, and then, of course, each agency has investigators. What we're seeing in the enforcement regime is an incredible coordination and information sharing in real time. And this is very important for contractors to realize. You may be making a disclosure or a submission to one office, but expect it to be shared in real time without delays with many other stakeholders. And for each of those stakeholders to have their eyes keenly focused on what remedies they can explore. Next slide. Now, in this context, with each agency and each stakeholder looking at the contractor and considering what action can be taken, you have to anticipate, contractors must anticipate parallel proceedings where each of these remedies are being pursued at the same time. And the panel today will talk a little bit about this and the considerations and the pros and cons of disclosures, keeping in mind that once you make a disclosure, it will be shared with the other offices. And if you're facing a suspension or proposed debarment and a parallel civil or criminal case, the information will be shared. So it creates all sorts of issues in this context and accelerates, in many cases, a contractor's investigation as well as the fact development. Now let's move on to the next slide and the hypothetical that the panel is going to explore deeply today. So we've set the stage with a very simple hypothetical. Foreign Parts Inc., FPI, for short, essentially receives a whistleblower report through its anonymous helpline, right? Some companies call it a hotline, some companies call it a helpline. So they receive this report, it comes into the ethics office, the compliance office, and the whistleblower has reported suspicions, concerns with the foreign origin of end products being supplied to the Department of Defense under a present longstanding IDIQ contract. So in this context, the whistleblower is expressing concerns that the company may not be in compliance with the origin requirements in that DoD contract. This could immediately give rise to a host of disclosure obligations as well as the proceedings we've talked about before. So now with that hypothetical, simple hypothetical before everyone, we're going to walk through the 5 phases as we've defined it. Let's move on to the next slide. In this first phase, we call it the internal investigative phase. Fred Levy is going to unpack the panoply of issues that contractors need to consider in this context. And Fred, I'd like you to talk through the different considerations you have when the contract is ongoing versus a historical scenario where it's a contract that's been performed and closed out. With that, let me turn things over to Fred.
Thanks, Todd. So, the first thing that's going to happen is let's just assume I'm taking on the role of outside counsel that's received a call from a client reporting the hotline allegations that the client received. A lot of how I recommend going forward is going to depend on what the specific allegations are and how specific they are. Can we initially focus on specific parts, specific products, specific contracts, or am I going to need to search more broadly? So the nature of the allegations that we've received are really going to control in large part how we decide to conduct the investigation. One of the first questions I would have in circumstances such as you presented is whether the contractor's hotline system allows for communications with the whistleblower. In some systems, and I find it very helpful, even though the whistleblower can make an anonymous complaint, there is a way for the company to post and to contact the whistleblower. And so that's one of the first things I would want to do in this situation, if possible. And there's 2 reasons for that. One is I obviously want to get more facts from the whistleblower. Do they have specific contracts, documents, parts in mind that I can somehow get a hold of? I actually had one situation where the contractor had me sit in the hotel room and the whistleblower came by and slid documents under a door. So I couldn't get them emailed to me because that would give away the source, but they were willing to come by my hotel and slide documents under the door. The other reason to reach out to the whistleblower is to let the whistleblower know that the company takes the allegations seriously and intends to investigate and to respond. And by doing so, the company may alleviate any feelings that the whistleblower has that he or she needs to reach out to the government to let them know about these issues that get them properly addressed. I want to make sure as much as possible that we have the opportunity to conduct our investigation and make the disclosure before the whistleblower feels the need to do so. So really helpful if I can reach out to the whistleblower. Then in this circumstance, I'm going to want to identify the documents and the people that I need to go forward with this investigation. With regard and determine whether there's a real issue. So with regard to documents, I'm going to want to focus on incoming receiving documents. I'm going to want to focus on purchasing documents. That's what I know of, immediately the types of documents I'd be looking at. I also want to get out a document preservation notice. We want to make sure, one, that we don't spoliate any evidence, and two, it's going to be important later on to demonstrate to the government that we've made every effort that we could to preserve any evidence that they want. So I'm going to want to look at those documents. I'm going to want to look at contracts or subcontracts that we have to identify what the actual contractual requirements are. I'm going to want to find out if my client has operations abroad where they're manufacturing parts or components, or whether everything that's coming from abroad is purchased. And I'm going to want to try immediately to identify the relevant personnel who can shed some light on the allegations. And that's probably going to be program managers and purchasing people who can identify for me where parts are coming from and what our obligations are with regard to domestic content requirements by American or TAA requirements, and interview those people. Let me just say that at this stage of the investigation, I want to make sure that everything is done under privilege. So I will give the requisite warnings or prefaces in conducting any interviews to individuals to let them know that it's a privileged conversation, that I'm representing the company, because I want to preserve the ability not to disclose, to preserve the confidentiality of any statements or communications, even though I might later want to make a disclosure, or at least the client would. One additional consideration is, and you alluded to it, Todd, is right off the bat, one of the first things I'm going to be trying to ascertain is whether I've got a historical non-compliance issue or whether I have an ongoing or potentially an ongoing violation. And that's going to be critical in this situation for a variety of reasons. I'm going to want to make sure that we don't have continuing violations. The client will want to make sure it doesn't have ongoing violations. And it could be under the circumstances that you've described that stopping ongoing violations or potential violations, if I don't have alternative sources of supply, might mean that we have to stop deliveries. And stopping deliveries is going to trigger a host of considerations about disclosures that we can get to a little later on in the conversation.
Yeah, very, very complex considerations there, Fred, particularly when you're dealing with the risk of potential ongoing violations versus historical. David, what I want to do now is I want to shift to the key subject on every contractor's mind following receipt of an investigative or whistleblower report such as this, which is whether to disclose. Let me unpack this first by setting the stage and just making sure the audience is familiar with the key rule in this regard, which is what we all call the mandatory disclosure rule. FAR 52-203-13. It's under the clause Contractor Code of Business Ethics and Conduct. And in section B, 3i, it states the contractor shall timely disclose in writing to the agency office of IG with a copy to the contracting officer whenever, in connection with the award, performance, or closeout of this contract or any subcontract thereunder, the contractor has, and here's the key language, credible evidence that a principal, employee, agent, subcontractor of the contractor has committed a violation of federal criminal law involving fraud, conflict of interest, bribery, or gratuity violations, or the broader violation of the Civil False Claims Act. So with that, David, why don't you unpack the issue of this, making the decision of whether there's a mandatory disclosure obligation and how you approach that, as well as a voluntary disclosure, the benefits and risks of both.
Sure, happy to do it, Todd and Fred. It's good to be with you for this one. Thank PubK Law again for inviting us back to do this one more time. I really like this scenario approach. It gives us a chance to really talk through a bunch of moving parts. And this one, we all need to address. I know you both address it too. Two fundamental questions. Do we have to disclose? And do we want to disclose? And that's what your question gets at, Todd. Do we have to disclose? Probably not, because we've just walked through a hypothetical which we have an allegation. We don't have evidence yet. We have an allegation. Were Fred able to talk to the whistleblower and get further documents or do a bit more investigation? We might find ourselves in a scenario where we have evidence, and whether it's credible or not, as you note, it's a low standard. It's not more likely than not. It's enough to get the government interested, for lack of a better phrase. We may trip into a mandatory disclosure obligation. And that's the first step in the analysis. But the second is, what do we get out of it if we raise our hands? Fred raised the point, do we have a continuing violation? Do we need to stop deliveries? That's a pretty dramatic scenario. I would sure want to be telling our story a number of different ways, both to the customer and using an abundance of caution disclosure, just to make sure everyone understands what we're seeing and why out of an abundance of caution, we're protecting the government by stopping delivery. But this is the nature of the inquiry we have to make. You've seen Todd walk through the rule. Credible evidence of a Civil False Claims Act violation is really hard to get to because there's so many questions. We need more information. We may get there eventually. There may be benefits to raising your hand, to keeping the government stakeholders informed, to control the narrative, to make sure our clients' stories are told. It's rare this early, though, that we have a mandatory must disclose scenario before we investigate.
Thank you, David. So as we work through these issues, Fred, and we try to unpack, the analysis of whether there's a disclosure obligation, and try to gain more information, as you mentioned before. All of these things are happening at the same time, simultaneously. Fact development, information, and strategy is continually being assessed and reassessed. When do you reach the point of thinking, should we disclose now? Should we disclose in 30 days? And what are the pros and cons of initial early disclosures before you have much information, like at the report stage, versus waiting a couple of months if that's what it takes to fully investigate the facts and make a more fulsome disclosure? Can you unpack and walk us through the timing considerations that come into place here?
Sure, Todd. But before doing that, I just want to add one additional thought to what David was talking about. And that is, sometimes, particularly from the perspective of a subcontractor, it's hard to make the determination as to whether the mandatory disclosure obligation is triggered. I mean, obviously, in a simple situation where there's labor mischarging, it's not hard. But I've encountered situations where, as a subcontractor involving quality issues, we're producing something to the prime's spec provided to the client, but we don't know what the client's obligations are to the government. And so it could well be that, for example, the prime built in tighter tolerances in my spec, in my client's spec, than it has in its government requirements, because it wanted to make certain that it had a little extra margins there. So sometimes it is just hard to ascertain whether you even, despite all of your investigating, whether something rises to the level of a mandatory disclosure without working with the higher tier contractor. going to your issue of timing, well, as I was saying earlier, a lot in this instance is going to be driven by whether I have a potential for ongoing violations. If I have ongoing violations, and I'm certain that it's a violation, or at least even a contract, if I'm not certain that there is misconduct, but that I appear to have a contractual violation, I might just decide to reach out to the customer or advise the client to reach out to the customer and to find out whether they want the client to continue, because the product or services is of such great significance that the government might want the client to continue to perform, notwithstanding the potential non-compliance. And of course, we want that well documented. But absent that situation, and the chances of the government telling you to continue to perform notwithstanding a non-compliance, it's pretty remote anyway. If I have a non-compliance and I have an ongoing violation, then I am my hands are tied. I'm going to need to reach out. I'm going to need to reach out everywhere. I'm going to need to reach out to my customer, whether that's the prime or the government. If you're the sub, sometimes it's hard to know who the contracting officer is. You might need to get that from your prime contractor. I'm going to need to make a disclosure to the IG. I'm going to, consider a disclosure to the SDO. On the other hand, if I can, I want more time to work my investigation, because ideally, before making any disclosure, I want to have ascertained pretty well that I've got a problem and that I can have corrected it. And so in those circumstances, what I've often done, if I can buy more time, or if I'm not comfortable yet with whether there's a problem that rises to the level of disclosure, but I want to make certain that I'm the one that's disclosing it before somebody else, is I send a preliminary disclosure to the agency to let them know that I have potentially identified a problem of a particular sort, that we are addressing it, and that we will report back to the agency once we've completed our investigation. If you're going to put in a placeholder disclosure like that, I think it's important to make certain that it is at least fulsome enough to let the government know that you have the situation under control and that you don't have ongoing non-compliances, if that's possible.
Fred, it sort of reminds me of prior cases Dave and I have had before when we were with the Air Force. And where a contractor goes ahead and makes a disclosure to one office within the government, I think in today's day, you pretty much can assume that the sophisticated contracting officer is taught and educated to send that immediately to fraud counsel and to the SDO's office, at least within DOD. So, if you kind of go into it with that expectation, that information is shared in real time, and maybe I'll turn things over to David on this, is what benefits do you really have once you're disclosing it, not to include the IG?
It's an important question, right? And I understand the predicate for the question, which is folks are trained to share, but the reality is they don't always share. And if we're not finding a clear and convincing, which is the wrong standard, but it's just what comes to mind to articulate the sentiment, a clear and convincing violation that is just adamantly requires a mandatory disclosure that goes to the IG, you may be better off communicating with the contracting officer. You may get some resolutions, you may get some waivers, you may get some insight that other people are having the same sort of problem, and there may be some benefit to just have a direct contract chain communication. Look, that said, right, you're rolling the dice on that one. They may well basically raise their hand and say, look, they're trying to pull a fast one on the government here. And then you lose the benefits of proactively telling your story and telling it to everybody. Todd, you and I know, and we've seen, obviously, Fred, when we were in the government, but we all have experienced this. We all know that if you don't include the suspending debarring official, who's not included by name in the disclosure rule, if you don't include the SDO, you're opening yourselves up to a world of hurt. Why didn't you include us? Why are you trying to hide? You're not framing the issues as well. So all of this is part of your calculus when helping a client navigate to whom should they disclose what.
Yeah, I think, David, that there's a low, there's a low evidentiary threshold, right? As you say, it's not clear and convincing, it's credible evidence. But sometimes we just don't have credible evidence,
right?
Of the fact that would give rise to a disclosure obligation. It's been my experience, I don't know if it's true for the two of you, that when a client makes a disclosure, there is a presumption that it is a mandatory disclosure and that there are certain consequences, financial and otherwise, that go along with that. So I am loath to call something a mandatory disclosure unless I think that there is credible evidence of a violation. Now, to your point, Todd, I think that, if I have in this case, if I have a non-compliance with a domestic content requirement, and I can't find any, evidence of, a systemic or clear or intent that rises to the level of a False Claims Act violation. I've got a contractual non-compliance, no doubt, but I might not have a civil False Claims Act case, and I don't want it to. And if it goes to, I've got to be comfortable that if it goes to fraud counsel, or if the contracting officer reports it to their counsel, that my election can withstand scrutiny. But I'm just not going to. My preference is not to defer to. It's got to be a disclosure to everybody.
I tend to, and I know I'm mindful of time, and I know we need to move along. I tend to agree with that, but I also tend to not ever put the words mandatory disclosure in any disclosure, ever. Because especially if we're dealing with something as nebulous as a Civil False Claims Act violation, which is judged after the fact by different people, it just makes more sense to say, we're disclosing this without anything that could be construed as an admission, like using the words mandatory.
Right, we disclose the facts, not any legal conclusions.
Yes, sir.
Right, and I think this just goes to show how complex this decision-making matrix really is, right? I think from the government enforcement mindset, which we've all had the opportunity to experience, I think it's a much simpler one. And in fact, SDO offices will often say to you, why didn't you just tell us? Why not share it with us? And look, the truth is it is a you're in the vague and gray area when you're talking about, okay, well, you went ahead and shipped non-compliant product, okay, and whether that was reckless or not, it's almost a heightened negligence standard, the way it's been interpreted, by the government, and the way it's pursued so aggressively. So it is very complex. And I guess, Fred, what you're saying is until you find evidence of knowledge in manufacturing those parts overseas, or whatever the particular violation is, you're going to not necessarily view it as a disclosure that's subject to the rule.
Well, look, under the rule, and you cited 52-203-13, but there's 9.42, there's obligations to disclose significant overpayments. But that goes under the FAR, those go only to the contracting officer. There's no requirement they go to the IG. So I am saying that unless I can find, and even making my decision conservatively, and trying to be as prudent as possible for the client. If I can't find credible evidence of something that triggers the mandatory disclosure rule, that doesn't mean I'm not going to disclose, but we might, under those circumstances, think that we have a contractual non-compliance and deal with it as such. And I've had circumstances like that where we have disclosed to the contracting officer. We have, worked on addressing the contractual issue and continued our investigation, and later on found facts that made us change our view of what had occurred and made a disclosure to the IG and to the to the other authorities. But at that same point, I was also able to say that we found the contractual issue that we immediately disclosed to our government customers to address while we continued our investigation.
Hey, David, as we unpack this a little bit further, and we've gotten a little bit out ahead of the issue of whether to disclose and the timing, but I think the key issue that we've all been walking around is who to include on this disclosure. Obviously, the rule, as I read it earlier, requires disclosure to the CEO, requires disclosure to the IG for that agency. You mentioned before that it does not include disclosure to the Cognizant SDO's office. Can you walk us through your considerations? Do you tend to disclose to the SDO whatever you disclose to the IG? Do you tend to, weigh different factors? Can you walk us through this?
Sure. Well, let's just understand what happens to the routing. And this is something that I think the email list was put together, Todd, when we worked in the government and worked on the DoD NASA Procurement Fraud Working Group. I'm sure something like that is similarly done today. Disclosures go into the IG. The IG blasts out an email to, among other places, DCMA, DCAA, all the various military departments, the Procurement Fraud Remedies Coordinators, the Cognizant investigative agencies, the Department of Justice, one from civil, one from criminal, and the suspension debarment shops. They're gonna get it anyway, right? I mean, if you send it to an SDO directly, it's sort of a tacit admission there may be some suspension debarment concern. Yeah, maybe. But the moment you lob something into an IG's office, calling it a disclosure, it's going to the SDO anyway. You might as well get some credit for bringing it there first. That's a key component to the analysis. There are times where I do advise clients not to include the SDOs, when it can be handled purely administratively, when it's probably a contract requirement that can be waived, but I don't want to be seen as sort of playing a fast one with the government by only communicating with the CO, then we'll loop in the IG. But more often than not, and I think, Todd, you probably do the same thing, more often than not, we're including the SDOs as well.
Thank you, David. Yeah, I would agree 100% on that. I think in listening to you two unpack these issues, to me, it seems like once you decide to disclose to meet the rule to the CO and IG, you may as well include the SDO. That's the most practical consideration there. But I can see the measure in making this decision if you're still at the stage of whether to even include the IG. At that stage, clearly you may be able to handle this administratively with the CO. Well, with that, let me move on.
Todd, just before you go on, you have a bullet up here on the slide in front of us that we haven't discussed, and that's David, maybe you want to address it, is that lead agency SDO.
Yes,
it's not always, there are some major contractors who have been designated constituents of one particular department of defense, one department or another of DoD. But then sometimes it's hard to determine lead agency.
Yeah.
And what are your considerations when your client has a multitude of government customers and the problem isn't just focused on a particular contract?
Right. Couple of rules of thumb and then a rule of being practical. The rule of thumb is the largest customer of the contractor generally will have lead agency. That means work on behalf of the government to deal with suspension debarment or be the final decision maker. So that's the one you want to go to, right? Sometimes there can be other interests. There could be statutory considerations, like when there's a Clean Air Act or Clean Water Act environmental concern, you may have to deal with the EPA, even if they're not your largest buying customer. So those sort of unwritten rules of government contracting matter to who your lead agency is. And the practical consideration is we get to do a little bit of forum shopping, for lack of a better phrase, right? We know the tendency of certain offices. We know what they care about. And we can bring something to an office that will probably be more interested in a particular issue, or give our clients a different sort of look, or maybe give us a little more leeway to further investigate. We're not pulling a fast one. The facts are the facts. The facts are getting disclosed, period. But we can make a showing that you should have lead agency X for the following reasons. That guides some of who you approach on the government side. You can't be too overt, because you get called out on it, and probably all the affected agencies will then pile on, and you get all 5 of them helping to make decisions for you. But that is a strategic consideration for all of us.
Well, and also sometimes it's just really hard to tell. So, and I'll give you an example. I've had a number of cases of late where I have been representing companies in the construction industry that are not typically prime contractors. They're doing a lot of federally funded work, but they not certain necessarily if a particular project has federal funds or not, and who's funding it. And in those situations, you know, I can't really ascertain even, and the client doesn't know, because they're a supplier of a particular product in the construction industry, for example, you know, who the, where they have most of their work. And interestingly enough, in those situations, I've reached out to multiple agencies, and I actually do get that question that you just raised, David. You know, prove to me why I should be the lead agency, which is difficult. I just need somebody to help, and sometimes it's you know, it's hard to get somebody to take in the government to take ownership.
Terrific. Well, I know we could talk about this all day. I want to move on to phase 4 and kind of set the stage by covering a couple of slides here and then coming back to my panel here. So first, in approaching the contents of a disclosure, you'll see on our slide in front of you, there's a number of considerations that you have to have in mind. It's not so much of just writing up end products were supplied from a foreign country, we've found a new supplier, problem solved. There's a lot more to that goes into it. And so what I want to do before going to the panel is I want to look at slides 13, 14, and 15 briefly here, because these factor in. When we're thinking about disclosing and the details of the disclosure, I want to draw some attention to memoranda issued by the Department of Justice in late 21 and then late 22 very recently. First, in this memo from AG Lisa Monaco, 3 factors were set forth in October of 21. One, a focus on individual accountability in making sure that the Department of Justice was considering the individuals involved, all of them, not just those that were substantially involved. And as David's annual reports on suspension debarment activity show, over 50, maybe even 60% of actions are against individuals. So this is very important. Second, the government wants to understand the full range of misconduct, not just the particular isolated misconduct in question, but all former state, federal violations. And then third, monitorships are on the table. Now, very recently, in I think November of 22, or September of 22, DAG Monaco issued a supplemental memorandum sort of expanding upon these items, but one, focusing on individual accountability and reiterating that principle, but talking about speed being of the essence in with disclosures, which is something the panelists talked about today, and having the opportunity to evaluate the matter as it's in real time and not years and years later, right? So that's an important consideration, as well as instructing the various DOJ components that they need to issue guidance on how a company can qualify for voluntary self-disclosure. Fourth, Monaco noted that prosecutors must complete their investigations into responsible individuals. So again, a focus on individual accountability before reaching a resolution with the company. So, these are the factors that DOJ is looking at here. And then I want to very briefly touch on these 10 FAR factors here, which are on slide 15. And because these are all the things you need to have in your mind in crafting a disclosure, right? So with that, Fred, I want to come back to you now at slide 12, and I'd like you to briefly touch on the components of the disclosure. Thank you, Fred.
Yeah, so look, notwithstanding Deputy Monaco's memos, I think it's always been important, particularly from the SDO's perspective, that one identify in any disclosure essentially what happened, who did it, when did it happen, and why did it happen. In other words, for the government is going to be interested in, not forgetting DOJ's perspective, the SDO has more and more focused on individuals and taking action against individuals. We've all known that for a number of years. They want to identify who in the company is responsible for the conduct and to ascertain that the contractor has taken appropriate corrective actions, either by terminating them or providing appropriate discipline or training, which can be a form of discipline, because that's all goes into whether these issues can happen again. You need to explain when it happened. In other words, is the conduct dated? If you had time to implement corrective actions that are working in the interim, and why it happened. All of that needs to be in there because the government is not in a position to evaluate, one, whether you fully understand the problem, and two, whether your corrective remedial measures are adequate, unless you can describe, who undertook the conduct and what were the circumstances that allowed this conduct to occur. And then three, what have you done to address it? Both corrective actions, remedial actions designed to remediate the problem. But I also like to talk about, in any disclosure, general ethics and compliance programs, because I want to convey to the government that my focus isn't only on, it's certainly, I'm attentive to the specific issue, that the client is attentive to the specific issue that brought us there, but that we have a broader interest in making sure that we don't have problems of any sort, and that we're committed to instilling the right corporate culture in all of our employees. So who, what, and where and when, I think, is basically what you have to address, and you have to do it fairly thoroughly.
Yeah, there's no question. There's a multitude of factors that need to be involved there, and I've seen a range of disclosures, sometimes so deficient in detail that you wonder whether they're actually of any value. I know this panel could talk about the contents of a disclosure, for days. David, let me ask you if there's any kind of key thoughts you have on this topic before we shift.
No, I think we've covered it pretty comprehensively. We can certainly move on.
So Todd, the one additional thing that I want to add, and another reason to make that disclosure pretty comprehensive, is that the more comprehensive and the more that you can demonstrate to the government, not only that you have fully grasped the situation, not only does that reflect on the seriousness with which management takes the issue, which is one of the mitigating factors in the FAR, but it also reduces the likelihood that the government's going to want to come in and do its own follow-up investigation. So as much as possible, if you're a client, if you're a company that's undergoing the pain of this internal investigation and disclosure, you'd like to do so in a manner that doesn't also lead to follow-up investigations by the government, if at all possible.
Certainly, certainly. Okay. Well, so we've gone through the first 4 stages of this, right? And we've done the investigation, we've made the disclosure now, we've made it, in one scenario, we've made it to the SDO's office that we believe was the lead agency. It was well received and the matter was resolved, maybe through an administrative agreement, maybe through no action. However, I want David to unpack this scenario where a contractor chooses not to make that disclosure to the SDO's office, and maybe walk us through some of the experience you've seen on both sides of the table.
Sure. Okay. I'll do this 2 different ways. The first way is no disclosure to an SDO and no outreach from the SDO yet. And then no disclosure to the SDO and, oh, surprise, surprise, here's a notice of proposed debarment or suspension. First and foremost.
David, I know you're going to do it quickly.
Yes, sir. I'm in the PubK offices here. There's no clock, but whenever Alan shows up, I know to hurry up. Here we go. When I don't reach out to the SDO and I haven't heard from them yet, I'm communicating with the customer frequently. I want to make sure they know what's going on. I want to make sure I get plenty of, waivers of any issues, acceptance of any issues, all sorts of mitigation in place, and build my record. I will eventually update the SDO when I know more, when I have a full story packaged and something good to say whenever it's possible. In the scenarios where I get outreach from the SDO in the form of an exclusion, well, that's kind of a problem, right? I will want to make clear to the SDO that we did disclose to the government, we have been in communication, but then you're sort of on your back foot and you need to get the SDO's office caught up to where you kind of wish they were in the first instance. So there's more to be done there. Given Alan's admonition to hurry up, I'm going to stop the answer right there.
Thank you, David. And I want to leave the audience with a very, very brief update. It's very unusual for there to be case law developments in the suspension debarment space, but a recent case out of the Eastern District of New York, July and August of 22, cemented the idea that for due process, the agencies must afford the contractor an opportunity to meet with the debarring official before a final decision is made. That case looked at both the meeting requirements as well as the fact-finding hearing requirements, and found that in this case, the Defense Logistics Agency did not afford the contractor their due process rights by meeting with the contractor and holding a fact-finding hearing. Before we turn things over to Alan, any final remarks from my panel here?
Just continued gratitude to be with you all for yet another year.
Yeah, thank you, everybody.
Thank you.
Yeah,
Alan?
I'm ready. Gentlemen, thank you very much. That was very informative. With these scenarios, they take you down so many tangents, and kudos to the panel for exploring so many of them. I like the way you figured this out in a variety of phases. There were a number of questions about the specific examples, and we'll come back to you on those. But let me thank again our distinguished panel, Dave Robbins, Jenner Block, Fred Levy from Covington, and Todd Canning from Pillsbury. Just did an outstanding job. It's why we invite them back year after year to do this panel, just a real expert at it. Let me also thank our sponsors, our event sponsors for today. Couldn't have done this program without them. They're listed on this slide and the next slide as well.